Commission. Because of the governor's direction, we are still doing this meeting virtually. All the answers will be in the chat box, and if anybody is willing to participate in the public hearing or the audience comments, please make yourself known. The way you can get in is on the internet, and Doug will let you in when it is time for you to speak. So the first thing we're going to do is ask Keith to take a roll call. Except you're on mute.
See, you know, you asked me to do real work, and I'm not sure I can get through it. Commission Chair Probola.
Here.
Commission Vice Chair Fowl. Not here. Commissioner Lewis.
Here.
Commissioner Reinhardt.
Here.
Commissioner Carl.
Present, thanks.
Commissioner Voice.
Here.
And Commissioner Bukers, not in attendance. That's the roll call.
Okay, so first thing normally that's on our agenda is the approval of the minutes. The minutes of October the 7th. I assume you all have read the minutes. Does anybody have any corrections, discussion, errors? Hearing none, the minutes of October the 7th are approved. The minutes of October the 8th. Do I have any concerns, changes, directions for the minutes for October the 8th? Hearing none, the minutes are approved. So tonight we're going to have a meeting on the proposed amendments to the Issaquah Municipal Code concerning construction hours. And I'm going to introduce Chris Grabowski, and the Code Enforcement Officer for the City of Issaquah, and he is going to lead us in a discussion of the proposals by the city.
Thank you. What is before the Planning Policy Commission this evening are proposed changes to the city's construction hours ordinance, which is chapter 16.35 of the Issaquah Municipal Code. The intent of this ordinance when it was adopted in 2016 was to regulate construction and construction activities in such a way that neighbors and residents of construction projects, permitted construction projects, were not disturbed by the noise and dust and other nuisances that go along with a construction job. As such, the ordinance limited the hours of work from 7 a.m. to 6 p.m. Monday through Friday. No work could occur on a permitted job site after 6 p.m. or on weekends or holidays, nor could it begin before 7 a.m. This has been going on with no changes to it since its adoption in 2016. We typically have a few violations per year. Since 2018, we've had 10 active code enforcement cases relating to violations of this ordinance. However, recently, based on citizen input, it became clear that some exemptions that the city was allowing as far as what is defined as construction activity was disturbing neighbors in the peaceful enjoyment of their residences. In particular, moving vehicles onto and off of a site fueling vehicles and doing other maintenance, sometimes relating to mechanical equipment or vehicles, was controverting the intent of the ordinance, which was to afford people, the reasonable enjoyment of their property. We discussed whether or not those activities could be deemed construction activity with the city attorney, and he felt that they were not. So to include those activities and make sure that they were covered under the ordinance, we have added a section under the definition portion of the ordinance that clearly stipulates what construction activity involves. That is sort of the meat of this amendment. There's also, we also added a section at the end of the code regarding exemptions, because there may be times when there's work that has to occur off hours. Those exemptions are maintaining a temporary erosion and sediment control plan. So in other words, if a business or if a contractor has a rain event and is discharging water because of, say, a blown silt fence, and that discharge is getting into the city system on a weekend or after hours, they need to take care of that. So that would be exempt from construction hours restrictions. Also, any measures that the city would deem necessary to correct a code violation would be exempt under the proposed amendment. That is, in brief, the general background and analysis of the proposed amendments. So I will defer back to Madam Chairman if you would like to ask any questions or have the commission ask questions.
Well, of course, we're going to follow our little standard procedure. And since there is a public hearing tonight, I'm going to open the public hearing and ask at 6:37 and ask Doug if anybody signed up to speak.
At this time, there is nobody signed up to speak.
Hearing that, I'm going to close the public hearing at 6:38 and open it up discussion among the commissioners. Does anybody? Joy has a question. Commissioner Lewis has a question.
Thank you, Joan. This is Commissioner Lewis. Keith, I'm curious, when you guys were finding that there was this discrepancy behind what was written in the code and how people were commenting on how sites were being used, were there any shareholder meetings, any stakeholder meetings that were held to kind of assess like if there was a common theme that was coming up as to why there was these, like whether it was moving trucks or refueling or all the different things that were happening that were non-permit related, that kind of like why those things were forming a pattern? Or was there any kind of meetings that were taking place to kind of establish maybe why there was this need kind of on the other side?
So Keith Niven, Director of Community Planning and Development. So Commissioner Lewis, I think, so let me give you my take. The city's work hours are significantly more stringent than other cities in Puget Sound. We have very tight work hours. And so contractors who are trying to maximize their work during the dry season, and obviously we left that apparently last week, they are trying to basically get full days in, which means, moving equipment, refueling equipment, doing things, maintenance on equipment, those kind of things they would like to do off hours while their crews are not on site. So my sense is that's why it's happening, like on Saturdays, or a fueling truck might come either early in the morning or later in the evening to access the equipment while it's idle. and not being used by the workers on site. So I think my guess is it's an efficiency thing for the contractors, just trying to get more done, in a given day, which has already been somewhat restricted by the city.
I appreciate that. When you just said, I'm guessing, has there been like a forum to be able to have like, did you guys do like a virtual like chat panel breakfast? I don't even know how you would do it in this day and age. Basically, of bringing together the shareholders of saying, this works for you, this doesn't work for us, whether it be, citizen boards, in our communities, or was there some sort of mediation process that kind of went through as this was being created, or is this the first time that this is kind of seeing the light of day?
So thank you for the clarification. Or focusing me on the task, the actual ask. So no, the city, so the department did not reach out to currently active construction sites to discuss kind of, how big of, whether this would be considered a hardship or how much of a change this would be for particular contractors. My guess is it would vary depending on different contractors, but no, we didn't do any outreach.
Okay. I guess, so when I first saw this, I kind of thought, well, like, what's the impetus behind it, right? Like, what's the data to say how many complaints have we gotten? How common is it that we're bumping up against this, needing this kind of reform? I had a really great conversation with Chris to answer some of my questions about that. And what I was curious about when I read it was wondering on the flip side, because on one hand, we're all at home more, that beeping of construction trucks backing up and kicking up gravel, you can definitely tell that we're all needing a little bit of extra love these days, and that can just definitely grate on you in the wrong way. So I can totally relate to communities wanting to find a way to kind of keep a little bit more peace, a little more order. But on the flip side, I kind of wonder, well, is there this need, and by continuing to have this, really strict adherence, I wonder if there's kind of a give and take maybe. Like, for instance, I think our hours right now are 7 a.m. to 6 p.m. and maybe lengthening that to 7, right? So we're going to say there's absolutely no activity other than the few mitigations we have listed. And that means that we're going to give and take, right? We're going to say, we're taking something away that has been used, right? We know that we don't want it to be used in this way. And so maybe giving like the extra hour, for instance, strictly on those Monday through Friday to kind of balance out what we're taking. I didn't know if there had been anything like that, but to me, that kind of seemed like a natural give to maybe compensate for obviously something that is on the flip side needing to be used.
So I think you touched on part of why the hours were set up the way they were initially. So the idea was that if construction happened while most people went to work, and then by the time they got home, which would be maybe 6, the sites would be being buttoned up for the night. That most residents would then be only slightly impacted by the noise and everything else from construction sites. As you mentioned, a lot of folks are working from home these days that may not have been when we initially adopted this ordinance in 2016. And as we talked about it with a resident just last week next to a construction site, it really hadn't occurred to me that what we had passed, which in my mind was the ability for most residents to not necessarily listen to construction activity all week long, has changed, and people are hearing it all day long. And that extra hour, I guess I know why you're asking the question that you're asking, but it feels like to me that people are still not wanting to be inconvenienced by construction activities. And I think what was suggested with these code edits maybe achieves what was expected by the council when they passed the ordinance 4 years ago, which is basically Saturdays and Sundays, except for exceptions, and Chris didn't really go into the exceptions a whole lot, but there is the ability for contractors to ask to work either longer or to work Saturdays, and there's a criteria process for which we would have possibly approved that. But for basically weekends to be quiet and feel more like their neighborhood. So, again, whether you agree with that or not, I don't know, but that's, I think, why we are pursuing the amendment now is to maybe better carry out what was maybe the intent with the 2016 code amendment.
I don't think any time is perfect. I don't like 7 in the morning, so you're just going to have to balance it out, and hopefully it'll go away eventually. I have a question from Commissioner Boyce.
Thank you, Commissioner Boyce here. And thank you, Commissioner Lewis, for that kind comment about the horse behind me. My grandpa was a sculptor. So that is actually one of the gifts he left us amongst many sculptures. And I also want to pick up on something Commissioner Lewis mentioned is I would be interested to know the volume of complaints the city has received in terms of how many projects and permitted projects have been built. Because as Director Niven had mentioned, Issaquah does have some pretty strict codes as it is. Full disclosure, I do work in this industry, and we work not only in Issaquah, but also Medina and Clyde Hill and Bellevue, and Issaquah is the toughest of all of them. So while I understand some of these people's complaints, not being able to work on Saturdays is a hardship for many contractors, and just continually constraining one of the few industries that thankfully has not been heavily impacted by COVID seems a little wrong-headed. I understand people are working it from home, but we have an industry that thankfully has not suffered like retail or restaurants, and just adding more limitations and more limitations on small businesses, because many of these contractors are small businesses, seems a little bit in the wrong direction for what may be very few complaints. I believe I read in the memorandum that there were 7 complaints from 2016 with the addition of a few more. I want to thank Mr. Grabowski for mentioning that there were 10 violations. I imagine those contractors or builders or companies have probably taken care of those violations, but are we adding additional hardships to people in one particular industry that has been a light through what appears to be a tough time for everyone? So I guess my question is, what are we looking at in terms of complaints? Are we talking about a dozen over 4 years? Are we talking about 2 dozen? What are we talking about?
So I'll attempt to answer your question, Commissioner. So we probably get between 15 and 20 complaints per year of construction noise or people working after hours on weekends or evenings. IPD is a good partner with me in this. A lot of times these violations are going to obviously happen when I'm not in the office. The citizens will often call IPD to make a noise complaint. And IPD will say, okay, fine, we'll go out and check it out. And what the police department will do is they'll just basically note the time and day and the type of activity that's going on, and they'll forward it to me. That's if the citizen calls it in. A lot of times I'll get calls from citizens just saying somebody worked this weekend, and I attempt to follow that up, after the fact. Contractors generally say, well, we weren't there, nobody, it wasn't us. So that, those are kind of dead in the water for me. I can't pursue those because I've got no real fact-based evidence to go and make a case. When I get a police report, that's good. And so typically what I will do is I'll contact the contractor and give them a warning. I'll say, I received a report either from the police or if it's a credible report from a citizen with like photographs and, times and things like that, I will tell the contractor, look, this is your first warning. The next time there's going to be a fine. All these contractors are, if they have a pre-con meeting with staff before the project starts, they're advised, what the hours of construction are and what the penalties are for violation. So it's surprising to me that we get any, but we do. Like I said, about 15 complaints, maybe 20 complaints per year. But, usually a warning takes care of that. But if it doesn't, I end up writing a fine. And those are the 10 cases that, resulted in penalties in the last 2 years.
Would you say, Mr. Grabowski, that most of these penalties come from weekend complaints, like working on a Saturday, or prior to dawn, after sunset? I mean, are they happening on Monday through Friday because people are getting there at 6:30?
Yeah, there's no. Sorry to interrupt. Yeah, there's no real pattern. I mean, they're a mix of all of those. Some are on the weekends, some are on in the morning beforehand, some are after hours. So I'm a certified community noise abatement officer as well. And the thing, you are correct, Commissioner Boyce, in that we are highly regulated in this city. Under state law, construction activity from a noise standpoint is typically exempted because of federal safety and OSHA regulations. Backup beeping of equipment is exempt from noise regulations. But it doesn't mean that it doesn't bother people. And noise is a funny thing. If it bothers you, it really bothers you. We're not, pointed out, contractors have the ability to apply for an after-hours work permit to do the work that's necessary, but they have to follow the rules. That's baked into the ordinance as it already exists. What we're trying to do here is just more clear, make it clearer, not only to contractors, but citizens as well, what construction activity actually means. It doesn't just mean swinging a hammer on site. It can also mean mobilizing, demobilizing, and other work that wasn't clearly captured because there was no definition in the original ordinance.
And I appreciate that, I guess, and I appreciate the effort because, again, I'm one of those people who live in a community, and sometimes they work a little long, and it is annoying when you're trying to do a Zoom call with the Planning Policy Commission and you can hear somebody hammering outside. So I get it. I guess my concern is, for the young people, or not young people, but for the people who show up at 6:45, I mean, are headlights now considered in this? Because the definition's pretty general, right? So any related, quote, any activity directly related to an active permitted project, end quote. So I guess, is pulling up to a job site is this something people are going to be flagged for? I mean, does everyone have to sit in their car till 7 a.m. or, possibly Mr. Grabowski is going to come after them in a pad? So those are kind of my concerns because, again, I understand what Director Niven was saying. That's most likely what's happening is they're trying to make more of their time efficiently work in Issaquah because they had Saturdays taken away. So again, I'm kind of worried about the little guys who show up at 6:30, 6:45. They start pulling their tools in. I mean, are these reasons to flag people? Or I guess that's kind of where I'm headed. It's a pretty general definition.
I agree. It's all encompassing, but I guess a little bit of sort of code enforcement 101 is in order. Violations are, if there's a gray area, officers are able to exert some discretion. I don't think that if a citizen called me and said, somebody's sitting in their vehicle waiting to go onto the job site and they're, radio, their window is down because they're smoking in their car and the citizen could hear their radio. Do something about that. I think I would tell that citizen that that is not a violation of this ordinance, because I agree with you. It would be an overreach to start, hammering contractors for, their employees just showing up to the job site. I think what we're trying to do here is more accurately define what construction activity is. And it's not always just being on the job site and doing work on the job site. It's taking equipment onto and off of the site and, maintaining equipment on the site after hours, fueling equipment. Those are, I think, reasonably construction activities. But I certainly wouldn't go after an employee or a worker sitting in their vehicle waiting to start at 7 o'clock.
I have a question from Commissioner Reinhardt.
Yes, thank you. This is Commissioner Reinhardt. Mr. Grabowski, so the first question is, so when a company comes in today and they get prepped on what they can and cannot do on a job site, are they given any kind of message that's related to this amendment, where they have to limit their activity outside of the standard hours? Do they receive any notification there? Or is this would this be considered a brand new amendment to them that they didn't see coming?
Commissioner, right now, when a contractor goes into a pre-construction meeting with staff, they're advised of this ordinance and what construction hours are, and the definition of what construction activity is would be new because it's a new amendment to the existing ordinance. So if this were to pass, then pre-cons from this point forward would explain to them what construction activity is. I mean, our attempt with contractors is to be very clear with them up front, because education is worth a pound of prevention, or education is prevention.
Got it. So today they don't receive any kind of message like, hey, these are the hours you can operate. Make sure not to do any maintenance before or after. Don't move vehicles around. That all counts. Like they don't receive that message at all. For them, it's all, any activity occurring at all on the site has to be within these hours, these days.
Correct. Right now, what they're being told is that construction activity is limited to these times and these days, and you can't do anything on site during those times. So moving forward, we will advise them what construction activity is defined as.
So, and I'll just jump in if I can, Chris. So I think, so you've got existing construction sites and they would have had their pre-con already and construction hours would have been explained to them. And so this will be a change. And so the city will need to go back out to those existing construction sites, assuming this amendment gets approved, and let them know that how the definition of construction has changed so that they can at least understand what's expected, because for everybody who's already kind of midstream, they've already had their pre-con meeting and they're already out there doing their thing. So if there's a change in the landscape, it would be incumbent upon us to go out and explain that to them if it gets adopted.
Okay.
With the assumption that if there is a real need to have some kind of constructions outside of those hours, they can come in and get a special permit, and the neighbors will be told that what's going on and it's only going to be for a short amount of time.
So just case in point, so the middle school that's being built at Talus, they have asked to work on Saturdays. the folks who live at Timber Ridge actually enjoy watching the construction from their windows. So they've said, bring it, let them do it on Saturdays. That gives us more to watch. So yes, we do make contractors connect with their neighbors, and we have some Saturday work going on right now.
Okay.
So that was my next question is, so what do the rules change to when a company requests that additional permit to work outside? Is that just standard, like they get an extra hour on either side plus a Saturday, or is it kind of tailored case by case?
So it's tailored case by case. So for some cases, there is a public benefit. So basically, one of the criteria that they have to demonstrate is public benefit. And them getting their job done quicker is really not a public benefit, although they all try to argue that point. But like, for example, if you had to, like say, do a new water line crossing of a road, right? So that construction in that street can either be done by closing a half street twice, or you could potentially close the entire street and get it all done in one night. So under a situation like that, we may allow for nighttime construction to minimize the impact on the community. So, but that's what they have to demonstrate. And for example, there's another ask that's coming where the school district is going to ask to work a double shift on the middle school. And the reason is because they're behind schedule and they need to work a night shift to get the school done by September, so they can open for their school year. So the conversation I had with their construction manager is talk to Timber Ridge, have a conversation with them, see if they're okay with nighttime construction. It'll all be inside the building, so it won't be outside construction activity. But that's part of the threshold that we've created is I don't want to get 300 complaints on a Monday morning because somebody was working on a Saturday.
Got it. And the last question I had, Keith, is so what's the average project time? They're not all multi-month projects. What's the average here that will have this kind of activity?
Wow. So I can give you some examples. I mean, a medium-sized building, you generally assume like a year and a half of construction, starting with site work, eventually moving to building, and then it's interior finishing. But then you have certain like residential projects where they may have like a couple phases. And we have a townhouse project in the south part of town that's probably going to be 3 years at the end of the day by the time they finish their last unit. So that's 3 years of basic constant construction. Now, when I mentioned wet weather, when we hit October, things change because it gets wet outside. We don't want people moving a lot of dirt. So what ends up happening is the amount of construction usually goes down from October until April, and then it goes back up again.
Got it. Yeah, being on the other side of it, so I used to do excavating when I was much younger, so I understand kind of the compressed rules and the very strict hours. For the amount of I guess complaints that sounds like we're getting, it just doesn't seem to me like it's needed that we need to become more strict on these rules or guidelines. That's my take on it. But thank you for answering my questions.
I don't see any more questions in the chat box. Are you guys ready to vote on this amendment? I need somebody who would make a motion. Nobody's willing to make a motion?
Walk me through it.
I'm going to interrupt, Joan. I've got a comment in the box. I want to try to give this dialogue one more minute. We obviously haven't heard anything personally from our esteemed chair or from Janice, but right now I'm feeling a little bit like we have some questions right now, Keith. I'm feeling like right now we have something that we see as being very stringent, right? And I think there's been some good comments and tones coming out. On the other hand, I'm also hearing that what you're finding is that intent hasn't really come through, right, in the last couple of years, and you're trying to kind of mash that up with what council had originally wanted. And I'm kind of thinking that there would be a happy medium that we can put forward, and saying that maybe if you would like to put something through that's more stringent, to maybe have that kind of like daylight savings. I don't have a calendar in front of me. So, but when you have that kind of time frame, when you like, because acknowledging right now, by the time that it's kicking off, 6 p.m., it's dark. Neighbors are wanting to eat their dinner and wrap up. When we're in the winter and we're home more, we're kind of nestled in a little bit. So I think having that forgiveness maybe for when there are those construction hours, maybe that whatever that daylight savings time is, you'll have to forgive me that, obviously hasn't quite ended, but maybe writing something into the code that's saying for that part of the year that maybe there is an extended amount of time, like doing a 7 to 7 or doing something that allows a little bit more give to allow, I just think of these small examples of somebody who maybe left their work truck, and he knows that his boss needs him to move it, before he goes to another job site on Monday, and then he's going to put his whole job in jeopardy if they've already had a warning or a violation. I appreciate that Issaquah has a very stringent code, but taking it so far, I feel like there needs to be another little give and take. So I would like to recommend something that has a little bit of wiggle room while still adhering to what the city finds was the original intent and hasn't necessarily been there. So I'm not sure if people are of that mind. So before we propose an amendment, I'd like to hear from everybody else if there's a change or something they'd like to see, or if people are wanting to pass this through as written.
Commissioner Voice here. I did not sign into the chat box, but I'm
Thank
going to
you
jump
for
in
saying
anyway.
that, because I'm there. Where are you?
I think Commissioner Lewis's idea is great. So possibly, and I understand the city's trying to better define something. So I actually don't necessarily have a problem with the city's trying to do. I do like Commissioner Lewis's idea because I'm a little bit disappointed that the city didn't do a little bit more outreach to some of the shareholders. Whether it's Taylor Morrison, whether it's some of these smaller builders, whether it's whether it's Costco, because again, they do have a stake in this, and they hurts their bottom line. I like the idea of maybe letting the city clearly define construction activity, but also putting something like a little amendment or amendum that says something about daylight savings. Because as to Director Niven's point, they have more daylight, and that's when the hours actually ramp up, right? Spring, so spring forward, all of a sudden the day gets longer. That's when construction's already on the up and up. These virtual stay-at-home meetings aren't going to last forever, so I don't want to write a code that's around, or write an amendment to the code that's based around what's a novel situation right now that could possibly hurt people down the line. So I like that idea. I like the idea of maybe putting something in there about daylight savings if staff can do that, where, again, to the director's point, once April comes, a lot more outside work happens because in the fall, people start coming back indoors. You can't paint houses in the fall. It's much more difficult. So I like that. I like that a lot.
Before I respond to that, I think Commissioner Carl has posted a question or comment.
Thank you. This is Janice Carl. Can you hear me all right?
Yes.
Yes.
Okay, thank you. I generally agree. I have no significant concerns with what we're discussing tonight, and I have no concerns with either the perspectives put forth by Commissioner Voice or Commissioner Lewis. Excuse me. I do have a question, though, and I can't tell from what I've read so far whether the exemptions or rules, et cetera, make any differentiation between different contexts of construction. And by that I mean, is it in a primarily residential area or is it a primarily commercial area? Because obviously if it's being constructed adjacent to the Costco complex, I really don't have a whole lot of concerns about them working off hours. But next door neighbors to me, I am a little more concerned. So if you could answer that question, I'd appreciate it. Thank you.
Commissioner, let me make sure that I understand your question. So you're asking if the code as it's currently written makes any differentiation for the zoning of the neighborhood that the construction is occurring in?
Yeah, I think that would be a reasonable way to frame it. Yes, thanks.
Okay. That is not how the current code is written. The current code, however, does call out the size of the job as far as the fine amounts go. But in particular, in response to your question, no, that's not how the code is currently written.
Keith.
Okay, so there was clearly two commissioners who are interested in daylight savings time, which I'm still waiting for them to get rid of that. So let me open or at least show you a different door and see what that looks like. So, you know, as opposed to trying to maybe do a quid pro quo and have a take and a give, maybe the question is, rather than a take, what if there's just more edges put on that? So, for example, you know, let's say a contractor finishes up on a Friday at 6 o'clock, and he's got a backhoe on site, and he knows he needs it in Monroe Monday morning, and so his plan would be to on Saturday transport it to Monroe. If I'm a resident or a neighbor of that project and I hear a truck backing up to the site and moving a backhoe, I'm just going to think they're working on Saturday, right? So what if those things that are happening after hours related to onloading and offloading and fueling requires notification to the city in advance? So, for example, if I'm a contractor and I want to work on Saturday, I don't ask the city on Friday afternoon if I can work on Saturday. What the rules say is you have to get your application in by Wednesday. All right. So if I'm a contractor and I know on Saturday I would like to move some equipment off site, what if it requires them to make that ask, right? And as long as we get that ask by a certain time, then the neighbors can get notified that what's going to happen on Saturday is the contractor's simply going to move some equipment off site, but they're not actually working. So that it satisfies maybe two things. It doesn't take anything away from the contractor. They just have to now be a little bit more communicative in what they plan to do, so that, you know, again, neighbors aren't surprised. And I think one of the things that we're trying to accomplish with this is better predictability for residents. Because if I don't think somebody should be working on Saturday and I hear construction equipment, that's just gonna make me angry, right? So this would potentially allow for a mechanism to communicate out to neighbors, which might be okay. And again, I'm just throwing that on the table, not asking you guys to necessarily embrace that, but just as maybe a different approach than recommending expanding the work hours during the dry season.
So I don't have any problem with the amendment as it's written, based on the fact that a contractor can get special dispensation if there is some need to work on Saturday, to remove a backhoe or to do anything else that is quick, easy, and not over the top in noise. So that's where I'm coming from. I don't know how you can put things in there specifically about daylight savings time or any other specific thing. I'm having a hard time doing that. I think that what the city has said and what they're trying to do, and what the fact that they're going out and informing the citizens that something is going to happen on odd hours, I think accomplishes what I would want as if something was going on next to me. My thoughts. So I see a comment from Commissioner Lewis. Do you have another comment?
Yeah, I wanted to respond to what Keith said. So I think what's nice is, so you're hearing that we're saying that right now this is super open-ended, right? Or as far as, actually it's the opposite. It's taking something and we're making it a lot more stringent. And so I like your suggestion of giving it some edges, right? Of saying, yeah, if you're, again, non-work permit related, needing to do something on your actual construction site, then having a 48-hour notice is required. But the problem is that right now we didn't do any kind of outreach, right? It would feel different to me right now if we had another 20 people on our call, because we know when people are grumpy about something, they don't mind telling us. But I'm not seeing that right now, Keith, right? You're kind of missing the outreach part for me to justify having something so stringent, right? I'm not seeing that kind of backup of saying this groundswell, there's been this huge problem. So I like this idea of putting a corner on it, putting an edge on it, allowing a little bit of breathing room on it. But this is the kind of thing that that you would propose when we're talking to shareholders. I mean, you would have a community say, yeah, it's a one-off, we don't mind that. And being able to have then, like Commissioner Voice said, being able to have then the other side say, yeah, we can work with that. But without having those stakeholders having this discussion, it's hard for me to say, that's the right corner. You know what I'm saying? Like, that's part of my recommendation is it gives this kind of more open-ended thing. So I like where you're going with it, but it's hard because I'm not either one of those stakeholders right now, right? So I would be happy to put forward something that says that exemptions need to be done, but that's harder to word with us all right now in our chat boxes, right? So I am understanding that you're probably not going to want a kickback, right, to staff to say, hey, let's look at this again, right? As far as I'm understand it, this is going straight to council's docket to be voted on. There's no in between right now from us to them. So being able to have that language created of saying, hey, we're going to add a little corner here, a little corner there, to be able to give that flexibility that somehow is needed. And yet, what is the framework then for how many people within 500 feet of the site need to be notified within 48 hours? Is that a taxingness on staff to then have to notify all those people within those 48 hours? Like, those things kind of still need to get worked out. So I like where you're going with it, but I don't know that we're going in a place that allows us to give a recommendation on it. Does that make sense?
Yeah, I understood what you said. So just to give you a piece of information, Commissioner, which may or may not affect your perspective, if you want to work on Saturday, we require door hangers within a certain distance of your job site. So the notification piece of this code and working outside of the set work hours is already set. That's already in code. So it would just be basically saying you would have to follow that procedure if you wanted to maybe say, do some stuff on Saturday in terms of fueling or moving equipment on or off the site, or stuff that we've defined as being necessary for that additional outreach. So I think the process is in place. Now, you're right. We haven't talked to 20 contractors, and gotten their opinions on whether this was going to be a deal breaker for them or not. But that's kind of the process we followed. I think, again, the perspective was, was there a piece of code that needed some clarification? And I think that's what is in front of you guys today is that belief that there is, just to increase predictability.
So who is responsible for putting the door hangers on? Is the city or the contractor?
Contractor.
Okay. And does he have a specific amount of area that he has to notify people?
It is. There's a certain radius of the construction site, and I don't know what that is off the top of my head.
Okay. That's okay. Just so I know that I would assume that the contractor should be required to do that, not the city. That
Yes.
would just cause more time expense for the city. So there is a question from Commissioner Voice.
More of a comment, really. Commissioner Voice, first let me just say thank you to my fellow commissioners for asking such great questions on behalf of such a great industry. I actually am in agreement with Director Niven in the sense that I know that you guys are trying to define a better definition between typical work hours, and I know there's procedures already in place for those Saturdays. So I really do appreciate the concept of having a contractor have the ability to reach out to the city and say, Director Niven, this is my situation. Can I get a one-time waiver to move this or do that? And then being able to give, 48-hour notice, having the city say, okay, and then possibly following the same path they already do for a Saturday. So even though not a big fan of a little more constraints, and also would have liked to see a little bit more shareholder involvement, I'm okay with it. I do like Director Niven's point, and I would like to somehow attach that to what we're sending. But I understand that the code was written in 2016. We've been living and abiding by these rules for the most part for 4 years. It's really just trying to narrow that a little bit down so we don't have people kind of going rogue on us and doing things that that are unfortunately causing complaints. Because again, I'm also a resident, and I don't like noise on Saturdays when I'm at home relaxing either. And I think it would take care of a lot of situations. I think a lot of situations in life are just better handled when people communicate a little bit better. So if there's a mechanism where contractors can contact your guys' office and say, hey, this is my situation. Can we do this one time and give the proper notice? I think that kind of alleviates my concern. But yeah, next time, it's always nice to have a little bit more breathing room, right, before we have to send this to council. And I think that's probably Commissioner Lewis's takeaway from, well, maybe not takeaway, but that's kind of what I'm hearing. And I would echo that, because sometimes we're getting these things and they're already scheduled to go to council like a week and a half later. And that's a little bit disappointing, at least from my end. So I'm okay with moving forward with this. I do like Keith's suggestion, and hopefully we can maybe attach that and then take a vote on it.
I don't see anybody else in the chat room. Any other comments?
I'm gonna jump in with some language and see if anybody likes it before I propose it as a motion. Right now, what I have is that any construction activity on a work site outside of the stated hours from 7 a.m. to 6 p.m. will require 48 hours notice to the city and community as dictated in Ordinance 2777. Keith, did that sound like the edge you were saying? Because we have to obviously propose, right now it sounds like there's a consensus to propose an amendment to put forward to pass this through. So to go off of your edge, I'm trying to write something that we can move forward.
Yeah, so super great. So like, this making chili on TV. So what I would say is I would almost change the definition to include like a new definition for ancillary construction activities. And then you could say ancillary construction activities include things such as, the loading and unloading of equipment from a job site, the fueling of equipment on a job site, and those activities, may be allowed. And I think we shouldn't say outside of construction hours, because I think those things would piss anybody off on a Sunday, right? But if it's a Saturday, so maybe we bracket when it could happen, like within an hour of normal construction times, or on a Saturday, given 48 hours notice to the city. I mean, I'm just kind of throwing words at you, but I would want it to not touch the rest of the construction activity, because there's a criteria for getting outside, and this is a different thing. This is really not construction. It's kind of like ancillary construction activities. And I don't know if there might be a better word or phrase for that. And maybe Chris has some thoughts on this because I'm monkeying with his stuff. So, at this point, anybody wanting to help craft that language, feel free to jump in the lake with me.
So, just stating that any ancillary construction outside of the normal hours needs to have a 48-hour. Do we have to go in and name each one of the possibilities, fueling and all that? It is ancillary.
So I think Chris would tell you, at least I'm going to tell you, the less I have to define things that aren't defined in code, the better. So if it's actually says these are what that is, then I don't have a contractor telling me that jackhammering a slab is an ancillary construction activity, or driving piles for a foundation is ancillary because it's not really building the building, it's all underground, right? So I don't want to have those conversations. So the problem with less definition is there's more discretion. And I think what we're trying to do is make it very predictable, both for the contractor, the city, and the residents. And so I would at least lean towards kind of clearly saying what we're calling this now new thing, which is in addition to what's already in code. And Chris, you unmiked, so I'm going to let you talk.
So a good rule of thumb with code is you want to be as clear as possible, but build in some vagueness, that infamous including but not limited to. I think what I might suggest to the commission is to remember where this is coming from, as far as what's driving this proposed amendment that we're spending this time deconstructing, and that is that what is defined as construction activity became sort of questionable, and on the advice of our attorney, we decided that these activities that maybe weren't considered construction activity should be defined as construction activity if we want to capture them under this ordinance. So I don't know if I'm really clarifying anything here or muddying the waters. It's, you can go either way. You can overdefine and you can underdefine, and both have there's pitfalls with both. Which is where officer discretion comes in,
If you name 2 or 3 things, what about the 4th thing?
And that's exactly right.
Come back.
And one thing I've discovered after doing this for 20 plus years is that as soon as you write something down, somebody will find a way to get around it, or they'll find some activity that you didn't define, and so you can chase your own tail forever on that kind of thing.
For what it's worth, if it helps, I mean, these documents and code are all completely littered with, it's somebody's discretion. It's somebody's discretion. I don't know if that helps, but that might be able to give it the vagueness. Because again, the city staff are going to do a great job of seeing who's trying to squeeze in a few extra hours and who actually has a legitimate case. Hey, I need a beer for 45 minutes and take care of this. And again, city code's littered with that type of language, so I'm not too worried about the discretion of the officer if that's the way we went.
And Commissioner Weiss, that's a great point. I'd like to also point out that our inspectors, sometimes the contractors will say to our inspectors in the field, hey, I need to go a half an hour over today because we got a late delivery, and we're working our best to try and get done on time. And the inspector will say, okay, sure. So, those kind of decisions are made in the field all the time. And the city doesn't have a problem with that sort of thing. Where we have the problem is when people surreptitiously are, doing stuff on a Saturday that they clearly shouldn't be.
So where do the fines go?
Fines go into the general fund. At some point in the future, I'd like to change that into, some sort of a nuisance abatement fund, but that would require council authorization at some point in the future. But right now, fines just go into the general fund.
So where are we?
Here's the deal. We can either you guys can make a motion, which you kind of almost got to, but then we had a lot more dialogue, or we can bring this back. Your next meeting is the 12th of November, and that would give staff time to draft an amendment. And I don't know if I know Chris has kind of got a schedule in front of him in terms of when he wants to get this done. But if it bumped a month, I'm not sure anybody's going to turn into a pumpkin, even though it's Halloween. I think you have a choice. I don't want to ever have the commission feel like we've pushed them through the door. So you guys can either work together and figure out any amendment that you might want to propose and then vote on it, or you can ask us to bring you an alternative in a month.
So first of all, I'd like to know, just kind of not on a vote, if anybody really wants to have an amendment, or if they like it the way it is. Let's start there. So who wants to have amendment? Two. And who does not?
Then I'm going to make this really easy. I'm going to make a motion to propose an amendment as Keith has done, because it doesn't sound like there's a consensus to have us kick it back to staff. So I'm going to make a proposal for a motion and we can shoot it down and then we can do the vote.
Yes, that's up to you.
All right. So, because the other thing is, if by kicking it back to staff, because the question for me is really like, what does staff prefer, right? Because what we want is to get the language right, to get the intent right, and so I haven't necessarily done that in the last 3 minutes. So if staff is like, yeah, we're hearing you and we want to take this on because we want to define the ancillary construction, then that's fine. But if you don't, then I'm happy to make this motion and have it get voted down. So it's kind of whatever works out better, because ultimately, obviously, this is our recommendation we're passing along. Our esteemed court reporter will report that that there was a minority who supported this, and we'll see what council thinks about it. So I am going to propose an amendment to the motion on the floor.
There is no motion on the floor.
I'm going to state an amendment to. There is no amendment on the floor. An amendment to.
There's no motion on the floor. You can just make in the motion any way you want.
All right, then I'm going to make a motion to amend the findings of fact as proposed to include that any ancillary construction activities on a work site outside and within an hour of the stated hours of 7 a.m. to 6 p.m. will require 48 hours notice to the city and community as dictated in Ordinance 2777, such as the removal of equipment from a job site and the refueling of vehicles.
Do I have a second?
I second that.
Any other discussion from the other three of you? Us. Okay, the motion is on the floor. All those in favor say aye. Oh, can't do that. Can't do that. Keith, you have to take roll. Get out your little picture. And you're on mute.
I owe you guys like $2. All right, let's start with the motion maker, Commissioner Lewis.
Yay.
Commissioner Boyce.
Yay.
Commissioner Carl.
Yay.
Commissioner Reinhardt,
No.
and Commission Chair Probola.
No.
That carries 3-2.
Mhm. Okay. So with that, Commissioner Lewis, do you expect the city to come, not the city, to Keith's office, to come back with a proposal?
I do
Or-
not. I expect our recommendation to be passed through to council to say that this is the wording I just badly did, gets passed along. And in between now and when this hits council's docket, Keith, if you guys want to brainstorm what and better define those ancillary construction activities, obviously I named 2 because I'm basing that off of the document that I read from you guys, but I obviously don't have an in-depth knowledge of what those are. And so allowing you guys that space to say, nope, we're going to create a definition, and that makes it a lot easier for us and our esteemed officers to be able to enforce, that's absolutely wonderful. That means you heard our comments and you're going back to council with a change. And you could obviously go back and say, we're sticking to our guns and, PPC and their novel thoughts. So I don't need to see this again on our docket unless someone else has a different feeling.
No, I was just wondering if the language that you proposed was the language that you are expecting, or if you wanted, if there was a problem in the planning department that the end result was the same, but the language could be shifted a little bit, you would be okay with that?
I am. I think that
Okay.
but again, that would leave staff to say that they're aligning along our 3-2 recommendations. I don't know
right.
what they are.
Well, that's true, but I mean, you would be comfortable if that's what they did and decided to go for it, if they changed the language just a little bit, but the concept was the same. I just want to be clear with that.
Yes.
Okay. So, moving right along, I just want to, since Kristen isn't here and she usually, what is the October 13th, 2020 council study session on the agenda for?
Deputy City Administrator Snyder, there she is. Her box moved. I think she has a report out for you guys.
Thank you, Keith, and good evening, members of the Planning Policy Commission. I just wanted to follow up on the Environmental Board discussion that Council had, and we are wanting to make sure that we close the loop with you if you have a discussion on a topic, and so that you know how that your recommendations and your comments were received by Council and how those conversations went at the Council level. So in regards to the Environmental Board, I wanted to follow up with you this evening and first start off by saying I think this has been said a couple of times tonight about pushing items through, and so I wanted to say that I regret that I think the Environmental Board item felt as though it was pushed through. But I do think it's important for you to also know that the questions you raised and the comments that you provided City Council, they really valued those comments. And so the Council had reviewed your recommendations in the letter that you provided and asked that the additional questions that you asked during your discussions, those answers will be provided at the next Council meeting. And so the next Council meeting where they're talking about the Environmental Board is this Monday on October 26th, and that will be their second touch with the Environmental Board. So following this meeting, I'll send you, I'll send the Commission members an email with a link to those items so you can see how staff have responded to the questions that you've had, given a little bit more time. And also invite you to watch the Council meeting on Monday. It's almost the agenda is almost all on the Environmental Board, so that should be pretty easy to track if you're wanting to tune in just for that item. Then, so the answers included in the packet. We'll also come back to you at the next Planning Policy Commission to let you know how that conversation went at council on Monday if you don't have a chance to watch the meeting. So just wanted to close the loop with you on that. I'll be emailing, like I said, a link to the packet with a response to some of the questions and comments that you raised in your last meeting on the environmental board topic.
Okay, thank you for that. So the calendar, so till the end of the year, we have 2 meetings. One on October the 12th and then later in November.
November the 12th. So November the 12th is a sign code. So Daniel Kenny, who's with Ogden Murphy Wallace, who's the city attorney's office, we've had him, asked him to basically update our sign code to be consistent with Reed versus the town of Gilbert, which basically says, you know, your temporary signs need to be content neutral. In other words, you can't regulate a politician's sign any differently than you would, you know, a church's sign or some other sign that's going out in the right of way. So basically it turned everybody's sign codes upside down, and you know that happened quite a while ago. I don't even remember how many years ago. We're a little late to the turnstile here. So anyway, he's going to go through that with you. There's not going to be draft code for you to review yet. So in the vein of trying to not push things through you guys in one touch, this is an opportunity where there'll be a high level conversation about what the update to the sign code is trying to accomplish. And then we'll bring something back to you, actually draft code in the first quarter of next year. So that's what that looks like. And then December 10th, so the Old Town architectural standards for single family duplex zone that you guys had the joint meeting with Development Commission. So that document will be back before you guys in its somewhat final form. All right. So again, that will be, so that'll be hopefully responsive to the conversations that y'all had with DC in the joint meeting. So that's what you'll see with that document. And that right now, that's what we have on the docket for this year.
So when we talk about the sign code, I know that almost every other city has already updated, changed, or whatever. It would be nice to kind of be able to see generally what some of the other cities have done, which their attorneys have said are legal and the way it should be. So it would be nice to know that. So either the next time or when it comes back to planning policy, it would be nice to know that.
I'll see if we can afford that.
With the money that you get from the construction.
Chris is already creating his special Chris Grabowski vacation account for that. I mean, no, just kidding. All right. So
Okay.
I heard Pier Cities. We'll talk about Pier Cities.
Yeah, it just would be, you know, kind of interesting to hear that. I just have a thought. I want to go back to the motion that Joy made and that passed. Was that, did that insinuate that we passed and continued on with what the city has done with the amendment? Or did we just approve the amendment?
I think you approved an amendment to the city's proposal. So the proposed code amendment that was in front of you, the amendment that you guys approved would be an amendment to that.
So in essence, we haven't approved the city's proposal with the amendment. Just to be clear.
Right.
So I need to go back and have a motion to approve the city's proposal with the assumption that the amendment's going to be included in it. That seems like a crazy thing, but thinking about what we approved, I didn't think we approved anything except the amendment. So if you would just make me happy and somebody make a motion to approve what I just said, I would really appreciate it.
I'd like to make a motion to approve the finding of fact as amended.
Do I have a second? Somebody seconded.
Seconded. This is Janice Carl.
Thank you. Any other discussion? Motion's approved. Well, Keith,
No.
you can take out your piece of paper.
Commissioner Lewis,
Yay.
Commissioner Voice,
Yeah.
Commissioner Carl,
Yes.
Commissioner Reinhardt,
No.
Commission Chair Provola.
Yes.
Okay, great. It passed.
Okay. Thank you.
Okay.
I didn't want them to come back and say you didn't approve anything. Is there any other discussion among the commissioners? On the agenda is an audience comment. I need to ask Doug if anybody signed up to make any comments.
Nobody has signed up to make any comments.
Thank you. Hearing nothing else, I'm going to close the meeting at 7:46. And thank you for your continued interest and the smile on Keith's face. So thank you.